So hi, my name's Raya MacKenzie. I am a lawyer as I was introduced with Jawl Bundon LLP, and my main areas are estate planning and estates matters. I also do some corporate and real estate, which helps complement it, but that's me. I'm going to start off this presentation with a few disclaimers. So remember, the advice in this presentation is just for general information and knowledge. There's no specific legal advice that I'm giving for your situation. If you want advice about your particular situation, you would want to meet with your own lawyer about that. Often with complicated estate planning, you're also going to want to bring your accountant or your investment advisor or financial advisor into that process as well. So this can be complicated. I'm just trying to give you some of the basics here, and just know that. The other thing I want to give you a disclaimer for is that lawyers are very risk adverse. So as we go through this presentation, you're going to see lots of things that you might find a bit fear-mongering, or things that I'll bring to your attention that could be concerns or red flags. I'm not saying don't worry about it, but remember that lawyers, including myself, always tend to look for the worst case scenario. Doesn't mean that these things are going to happen to you or happen to someone you know. We just always provide the full range of risks that could occur as best we can. And you'll see throughout the presentation, I'm going to go over some fake scenarios with you of different characters that I've created to illustrate some of the points. And you'll see that those characters don't always choose the most or the least risky option. They sometimes choose an option that's in between the most protective and the most risky, somewhere in the middle. And that's generally where most of my clients fall. A lot of people could choose the most safe, most secure method of planning, but those methods of planning often come with their own disadvantages, which we can discuss in a bit. So just remember that if you go to your lawyer and they tell you a bunch of scary stuff, or you see a bunch of scary stuff in this presentation, always remember that we're erring on the side of the worst possible case, and that the worst possible case does not always happen. You're going to see some photos in this presentation. Just letting you know that the photos are not of real people. They are from images I found on the free commons on the internet, which are fair use, but they are not real people or real clients. We're also going to have some basic assumption of prior knowledge of estate planning. So some of you have probably seen my presentations for TV vets from past years. If you have, then a lot of the key terms will be familiar to you. I'll try my best to keep everyone on the same page, but this is a bit of a more advanced topic than my prior presentations in the past. We're really talking about blended families in particular, and how things can go especially right or wrong when you have a blended family situation. So I'll go over the key terms here. For those of you who've seen my other presentations, these should be review for you. The last will and testament are the will. Most of us know what that is. That is the document that distributes all of your property on death. Assets and property. I will use those terms interchangeably. They mean everything a person owns. And I say that because sometimes non-lawyers confuse the term property to mean real estate. And I don't mean that. When I say property, I just mean everything you own: real estate, investments, bank accounts, fancy china from your grandma. Everything that you own is property. I try my best to use the term assets more often when I'm speaking to non-lawyers, because that's a really clearly does not necessarily exclude property that's not real estate. An estate, that is a legal concept that comes into being after a person dies. So when a person dies, the legal entity that now becomes in their place is called their estate. And that estate is controlled by the person responsible for it, who is typically the executor. An executor can also be called an administrator when there is no will, but that person is responsible for the estate, and the estate has to file its own tax returns. So that is what that is. Joint tenancy or joint ownership is another term we're going to be talking about. This is the concept that two people own 100% of an asset together with the right of survivorship, meaning that the survivor will inherit 100% of that property when the other one dies without the need for that asset to pass through the will of the deceased. I like to use the example of an orange. Two people, if they own an asset in joint tenancy, own 100% of that orange together. They both own that orange. They don't own one half to him, one half to her. They together own that orange. And if one of them dies, the orange just passes right over to the other as a whole orange. Tenancy in common or ownership in common means that two people own 50% of an asset with no right of survivorship. So they can pass their 50% of that asset onto their own family. And for this, I like to use the example of cutting an orange. So you can own a whole orange together where the orange passes from one to the other when you die, or you can own an asset like half of an orange. The orange is sliced down the middle and one of you owns half and the other one owns half, and you can pass those halves separately to your own descendants or your own family. Okay, wills variation. What is it? So many of you probably think that you can make a will however you want. Some people even like to threaten disinheriting their children, saying, oh, if you don't do this, I'm writing you out of your will, of the will. Hopefully none of you here, because it's pretty harsh, but I have seen lots of that kind of behavior from some of my clients, and they are always surprised to learn that that's not really how this works in British Columbia. So yes, you can make your will however you want. You can leave your will to your estate to your distant cousin in Michigan if you want, and not leave anything to your spouse or children. But if you do that, you will be giving your family a very good claim under Section 60 of the Wills, Estates, and Succession Act. We call it WESA among lawyers. You'll be giving them a right under there to contest your will and say, this does not make adequate provision for us. Court, please change this will, vary this will, so that we inherit a fair portion of our family member's estate. Variation occurs most often in a blended family. The classic division is usually the spouse of the spouse of the second marriage or a subsequent marriage against the children of the first marriage is a very common phenomenon. So the parent might say, leave the majority of the assets to his children of the first marriage, and the second spouse would stand up and say, I want more from this estate because I'm the second wife and this is unfair to me. Wills variation can only be done by a spouse and children. So it is not a right that your second cousin from Michigan has. It is not a right that your sister or niece or even grandchildren have. It is only the right of spouses and children. Adult children are included, though, keep in mind. So we're not talking about just minor children here. We are talking about fully adult independent children, and we'll get into that in a little bit more. Also keep in mind, this is distinct from family law claims, though the legal analysis is often similar. So a family law claim is what happens when you divorce or separate from your spouse. And that typically is going to give them the right to 50% of the family assets, half and half. Wills variation happens when you don't separate from your spouse before your death. You're married right up until your death, but now your spouse wants a greater share of your estate. And this does not mean 50-50 is the presumption. There is some legal analysis that can err on the side of giving the spouse 50% of the estate, but that is not the automatic presumption like it is in family law. All right, so I'm going to talk about who a spouse is. This is one that also can come as a surprise. So obviously, legally married spouses are spouses under estates law, but also common law spouses are spouses under the estates law. So these are people that are living together for 2 or more years in a marriage-like relationship. The spousal relationship ends when a couple live separate and apart with the intention of ending this relationship. So that is when the relationship ends for both married and common law. It's not divorce necessarily. It is when you are no longer living together in the relationship. For the most part, common law and married spouses are treated exactly the same for the purposes of estates law. The only difference is sort of when they can make certain claims. So there is an extended limitation period for married spouses who are not divorced. So you're separated, but you're not divorced. I won't get into that here. It's a little bit complicated, but just be aware that if you are separated from a spouse, so if you were legally married to someone, you separated, but you did not get divorced, that can raise some issues for your estate. Okay, so big question I often get is, when are people in a marriage-like relationship? So we're not married, we're living together. When are we spouses? There is no one checklist. So all the law says is a marriage-like relationship for 2 or more years. The court is going to consider whether the couple demonstrated the types of behavior which contemporary society associates with marriage. And the courts are really strong on saying there is no one checklist, there is no one checklist, there is no one checklist. But when we read the case law, you can see there's a lot of things that the court considers. There are some factors in common. I think what they mean by checklist is that there's not just one factor or one series of factors that will be determinative. So there's not just one thing you can do or not do where the court will say, yes, of course, they are spouses. They're in a marriage-like relationship. But I do think there are some common factors which we'll look at here. So common factors would be living at the same residence, sexual intimacy, of course, sleeping in the same room, domestic chores being shared or divided is a really common one. So who did the cooking, who did the laundry, not necessarily falling into the traditional male and female gender roles, but something like the division of labor, taking trips together, recognition as a couple by family and friends. This is a really important factor the court looks at. Did your family and friends perceive you as a couple? Expressing affection to one another, making major decisions together, sharing property, so joint accounts, real estate, safety deposit box, anything shared. Filing taxes as common law spouses obviously is a pretty good indication that you are, in fact, in a marriage-like relationship. Taking care of each other when ill, prioritizing the needs of the other, having a close relationship with the other's children and or family, the intention to remain together long-term. This is also a big one. The court is not generally considering a relationship that is meant to be a quick hookup or a couple dates to be something that is marriage-like. They want to look for the intention for an indefinitely long relationship, and emotional interdependence and attachment. And as I said before, none of these factors are 100% determinative. So this is a case, a fairly recent case that came out, which was a little bit shocking for some of us in the legal community, in that the legislation says living together in a marriage-like relationship, but in this case, the couple did not live together, and they were still found to be spouses. So the facts are summarized together, summarized on the screen a bit. Essentially, it was 2 women who were in a romantic relationship. They had lived together in the past, but later on they were not able to live together because of some caregiving obligations that one of them had to their mother. And also they were not living together because of cultural and religious factors. They were both Catholic and Filipino, and same-sex relationships, these are two women in this case, were not favorably looked on in their community. And the court found in this case that they were in a marriage-like relationship, even though they had not lived together for many years. They were still emotionally and domestically dependent on one another and integrated into one another's lives to such an extent that they were found to be spouses. Now, you might think, well, this is a pretty specific case. What would this have to do with more common situations? I think what this shows is that the court is going to look for relationships that are not, where the people do not live together because of some perceived community judgment. The court's essentially saying that if you don't live together because of a reason like that, you can still potentially be found to be spouses. So the example I thought of was a second marriage or second relationship between, let's say, to make it a little bit easier, a heterosexual couple, man and a woman. Let's say the man's children really dislike this woman and would not be accepting of them living together. Perhaps they do not live together because of that dislike of his children. Potentially, on the basis of this case, the court could find that they are still in a marriage-like relationship, even though they don't live together, because the reason they don't live together is not for their own real choice, but because of a perceived judgment from their community. So, not sure yet. We haven't seen too many other cases like this, but you don't necessarily have to live together, which is new news to us. Go over who is a child. So just very quickly, it's only legal children who can make a claim against your estate under the variation provision that we talked about a little bit earlier. So stepchildren cannot make a claim unless the deceased legally adopts them. And if you had children that were biologically yours, but then legally adopted by other parents, those children cannot make a claim. They're not legally your children anymore. And then, as I noted before, adult children are able to make a claim even if they are financially independent, even if they are wealthy, even if they are doing well. Your adult kids can still make claims against your estate. This is fairly unique in British Columbia. Lots of other provinces don't allow for independent adult children to make claims against their parents' estate, but that is not the case here. I think I said this before, it's often the second spouse versus the children of the first marriage, in whatever combination that might be. So maybe the children of the first marriage want more because more is being left to the spouse, or the spouse wants more because more is being made given to the first children. And the court's looking for what a prudent parent or prudent spouse would do in the same circumstances. So there's no one size fits all answers. When you're looking at how to balance the needs of your spouse and children, it's very, very fact specific on your particular circumstances. You're going to want to consider the needs and means of the spouse and children. So what do they need, and what access to funds, means do they have? Remember, the spouse has a legal and a moral entitlement. What we mean by this is that if the spouse were to separate from you, they would have rights under family law. So that's the legal claim. And they have a moral claim because they're your spouse. Independent adult children only have a moral entitlement. Because they are independent now, the court will often treat their claim as a little bit less than the spouse, because they would not have a legal claim such as the spouse would have in the event of a separation. Also keep in mind that courts will award amounts which far exceed adequate provision in the normal sense. So for most people, we think, what's adequate provision for my spouse or child? Well, enough that they can, I don't know, perhaps live comfortably for a few years after my death. Like, especially in the case of adult children, you might not think it has to be an exorbitant amount. But if you have a large estate, the court can award quite significant amounts that we would think are well beyond what would be adequate. So here's some considerations that I'll talk about that the court looks to when deciding how much a spouse should get. So a spouse is making a claim against an estate. What is the court going to consider when determining how much of that estate they should get? So perhaps the will did not leave the spouse very much, and the court is considering what to do now. They're going to consider what the spouse would have received in the event of separation or divorce. So that's half of all the family property. They'll consider it. They won't necessarily order that that's what they're getting, but they will factor in that figure of about 1/2 into their analysis. They're also going to think about what the spouse would have received if the deceased did not make a will. So if you don't make a will, a spouse is going to receive a preferential share. For a blended family, that preferential share will be $150,000 plus half of the estate. So that's a little bit more than what the spouse would have received in the event of divorce. The court will also consider the length of the marriage and the sacrifices made from that spouse during the marriage. So did they caretake? Did they stay home? Did they, what did they do that gives them maybe an extra entitlement? They're going to look to the ability of the spouse to provide for his or herself after the death of the deceased. Obviously, like a retired spouse who's not working is going to be entitled to more than one who's still able to earn an income. They look to the lifestyle of the spouse when the deceased was alive. So if the spouse was accustomed to a high live-in champagne style life, the court is going to look to preserve that lifestyle so that they are not disadvantaged by the death of the deceased. They're also going to look at the needs of the other beneficiaries, so the adult children usually, even if those adult children are not disabled in any way, do they have high financial needs that might result in them receiving and balancing the estate differently? They'll look at the source of the estate. So where did it come from? Was it accumulated during the prior marriage, or was it accumulated during the second marriage? So in cases where the deceased accumulated most of the wealth during the first marriage with the children's other legal parent, their mother or father, who's now either divorced or passed on, the court will often favor the children a bit more because that money was earned sort of as a result of their parents' union, not so much as a result of this subsequent spouse. And the court will also consider the gifts made to the spouse prior to the death of the person or the assets inherited by the spouse outside of the estate, such as assets in joint names or joint tenancy with that spouse that are passing outside. Like, for example, if the second spouse and the deceased were on title to their home together, the court would consider, well, this spouse has received a home from, it's not passing through the will, but we need to consider that gift when assessing how to divide the assets that do pass through the will. So here are the adult independent children. What are the considerations with them? So this would be your spouse is fine, they're happy with your will, but your adult independent children say, no, thank you, we want some more. We want a bigger amount from this estate. The court will look at the reasonable expectations of the children based on the relationship with the deceased. So did the deceased indicate that these children would have money for university? Did he indicate that they would have a down payment for their home or that he would pay for their wedding? Those expectations are going to be taken into consideration by the court. As I talked about a little bit before, they're going to consider the source of the estate. Was it accumulated during the first marriage or the second marriage? They're going to look at the ability of the children to provide for themselves. Usually this is a bit higher for the children than for the spouse. Usually the children are still working, they're not retired, they're more able to provide for themselves. They will look at sacrifices made by the children and caring for the deceased parent, if any. So not all children step up to the plate, but if they have, the court will consider that. The strength of the relationship between children and the deceased parent is a factor. How close were they emotionally? The court also looks at childhood suffering or deprivation of the adult children. It's kind of in a way to compensate them through their parents' estate for any negligence on the part of the other parent, bad parenting, absence in their lives, childhood poverty, anything like that. The court will often try to award the children more money, essentially in a way to compensate them from that. For that. If there was an estrangement between the parent and child, whose fault is it? The court is going to generally place the blame on the parent, unless the child did something truly awful. Again, they're going to consider gifts to children made prior to the death or any assets that pass to the children jointly or otherwise outside of the estate. And then my little note here, it is actually very difficult to absolutely disinherit a child. The court does not like it. Unless your child has done something egregious, like try to murder you, steal huge sums of money from you, or otherwise be really awful, the court does not like it. There are other ways that you can go about organizing your estate to, in effect, disinherit your children. But those are done by essentially stripping your estate of assets so that there's very little passing through your will that your disliked child could claim against. That is more how it's done. Disinheriting a child through your will is not really going to work because of the variation law. Okay, hopefully I can get through these here because I would really like to. I'm going to take you through some common problems or conundrums. These are just fictional people that I've made up, but I think it illustrates the kinds of blended family problems that we can encounter. So I'm going to explain the facts of them to you. There's 3, and then I'm going to talk about some tools that could be used to solve some of these problems. So the common conundrum number 1 is the long second marriage, and I have called these people Fred and Mary. So Fred and Mary are in their 80s. They married in their early 50s, and they've been married for 32 years. And Fred has 2 adult children from his first marriage. I've named them Janelle and Sarah just to keep everyone straight. Mary has 1 son named Brian from her first marriage. Fred and Mary's children were young adults when Fred and Mary married. So Fred and Mary did not raise these children together. These children were already adults when Fred and Mary met each other. Fred and Mary do not have a marriage agreement, also known as a prenup. So there's nothing that Fred and Mary have agreed to about how their assets would be divided. They're both retired, they have worked, but they're both retired in their mid-60s. Fred and Mary, because they've been married so long and they love each other so deeply, they all hold their assets jointly, and they want to make identical wills, leaving everything to each other. And then when the last of them dies, they want to leave everything 50% to Fred's kids and 50% to Mary's son. So what is the problem with this plan? Well, if they hold all of their assets jointly, they own together 1 orange, that all those assets will pass automatically to the survivor. So let's pretend that it is Mary who survives. Mary will inherit all of the assets, 100%. Now, when that happens, we are stuck with what Mary's going to do. So Mary could be forthright and say, yep, I'm going to keep the will the same. So when I go, it's going to be 50% to my kids and or my son and 50% to Fred's daughters. That's fine. But she can still change her will. You always have the right to change your will. So what if Mary is offended by Fred's children? They don't visit her enough. They say something offensive, and she decides that she's going to write them out of the will. She's going to entirely disinherit Janelle and Sarah. She can do that. And when she dies, Janelle and Sarah will have zero, zippola, no claim against Mary's estate because Mary is not their mother. She is their stepmother only. That is a problem. The other thing that could happen is Mary might be really honorable and say, I am going to leave 50% to my son and 50% to Fred's daughters. That is what I am going to do. And she does, and she dies. Well, Mary's son, Brian, can stand up and say, but she's only my mom. She's not your mom, Janelle and Sarah. I want more of this estate because I'm her only legal child. And he can make a claim for more. So those are some of the issues in Fred and Mary's overall plan here. All right, my common conundrum number 2 is an intent to prioritize children. And I've named this lovely lady Laura. So Laura is 60 years old and recently retired. She's been living with her boyfriend Paul for 5 years. Laura is significantly wealthier than Paul. She's done a great job. She's a very successful and independent woman. She's got 2 adult children from a prior marriage, and Paul has no children. Mistake, Laura did not enter into a cohabitation agreement with Paul when they got together. She probably should have done that, but oh well, too late now. Laura keeps all of her assets separate from Paul, so that's good, including the home that they live in. So she has all of her stuff. He just lives with her, but he doesn't have any joint assets with her. And Laura's plan is to make a will, leaving Paul the right to live in the home they share for 2 years. So fair enough, he's living with her. She doesn't want to kick him out. He can live there for 2 years after she dies, and then the rest is going to her own children. Okay, so Laura's plan likely makes sense to lots of you. Why would Laura leave money to her boyfriend of only 5 years when her children are more important to her life and she has earned most of her money, during when they were growing up? But the problem here is that this plan does open up a potential claim for Paul against Laura's estate. And Paul would likely have a very good claim that it is not sufficient to provide him just 2 years of free living in the home, especially since Laura is wealthier than Paul, and he probably depends on some of her income or her assets for the lifestyle that he maybe have become accustomed to. And for each year that the relationship continues, Paul's claim becomes stronger and stronger. So perhaps at 5 years, this right to live in the house for 2 years is a bit more acceptable. But if Laura makes her will now and she lives with Paul another 15 years, that's going to look more and more inadequate to the court and to Paul potentially on what he should receive. Okay, this is a complicated one, so sorry, everybody. Complicated children is another one that we often see. So I called these people Yasmin and Tim. So I pretended here that Yasmin is 50 and Tim is 60, and they've been together for 27 years, and they have a very blended family. So Yasmin has a son, Marco, and Tim has a daughter, Amy. When they met, these children were very young, and they raised those 2 children together as if they were their own. And then they've got one son together named George, and all of the children are now adults. Tim makes things more complicated by also having another son, David, who was 15 years old when Yasmin and Tim met. So he wasn't raised by them the same way that the other kids were. And he is a son from Tim's high school relationship, I've said, and has been raised entirely by Tim's ex-girlfriend and her family. Tim used to see David 3 to 4 times a year when David was growing up. But now that David is an adult, it's more like once a year. Good old Yasmin and Tim have some joint assets, and they've got some separate assets. So they've got $500,000 separate and $250,000 together. And their plan is to make identical wills, leaving just $25,000 to David They think that's sufficient for him since they didn't raise him the same way they did the other kids. Then they're going to leave everything else to each other. And then when the last of them dies, it will be divided equally among Marco, Amy, and George. Those are the children that they raised together. All right, so this also creates some problems. So I'm going to again assume that Tim is going to die first because Tim is the older of the two. So when he dies, his $500,000 that he owns separately, off the top, $25,000 will be paid to David, or that's how it's supposed to go, and the rest would go to Yasmin. However, David has a very good claim. David is the son from Tim's high school relationship. The court tends to presume that you are going to treat your children equally, unless there is a very good reason why you would not. So David can definitely make a claim against Tim's estate to say $25,000 is not acceptable, especially since he could claim Tim was not an active parent in my life. I suffered childhood deprivation from not having Tim in my life, which my siblings and step-siblings did not have. I would like to make a claim. But let's say that David doesn't make that claim and the rest of Tim's estate just passes on to Yasmin. This could also cause problems for Amy. So Amy is Tim's biological daughter, but she is not Yasmin's daughter because no one legally adopted anyone in this family. Amy could have a problem with the fact that Tim is leaving almost all of his estate to Yasmin, because again, similar to Mary and Fred, Yasmin could change the will. She could change the will at any time to totally disinherit Amy. And Amy also might be concerned that her brother George could come against her for getting a higher share of Yasmin's estate eventually. So this also creates problems, as you can see. I'm going to talk about some legal tools that we will often use or recommend to try to solve some of these conundrums. I'll try to go through it fairly quickly, and then I can show you how they're applied to these these fake people that I have invented for you. So we're going to talk about cohabitation agreements or marriage agreements, severing assets, excluding assets. We're going to talk about trusts, mutual wills, and statutory declarations or explanations. So that's just my little outline, but I'll go through each one. So a cohabitation agreement or a marriage agreement, that's an agreement between two spouses regarding how assets will be divided if the couple separates or if one of them dies while you're still together. These are very good things to have. They're very helpful. They provide a guide in either circumstance. It's easiest to enter these early in the relationship, often before you're actually living together or before your spousal relationship begins. It's a contractual right. And what I mean by that is that it has to be enforced. You can't just say, you agreed in this agreement to do this. That doesn't necessarily force the person to perform the agreement. Sometimes you have to enforce it by going into court, but it does create this contractual right. The other note is that the court doesn't always absolutely uphold the agreement, especially if the circumstances of the two people have changed a huge amount from the time that it was made. But the court will give the cohabitation or marriage agreement a large weight. They will consider it very heavily when they decide how the estate in this context would be dealt with. Okay, again, they're called cohabitation or marriage agreements because a cohabitation agreement would refer to a common law or marriage-like relationship. Marriage agreement obviously refers to when you're legally married, but they're often used interchangeably. And even if you have a cohabitation agreement from when you were common law and then you legally get married, it still applies. So kind of the same thing. All right, severing assets. This is another tool that can happen to deal with some estate problems. I call it slicing the orange. So you can take assets that you held together, jointly owned 100% together, and you can slice them in half so that one of you owns half and the other one owns half. And one of you can pass that orange to his kids, and one of you can pass that orange to her kids. And you can do this secretly for some assets, such as real estate. You can't do it secretly for bank accounts, but you can do it for real estate. So you can slice the orange without your spouse even knowing that you've sliced the orange in the case of real estate. It doesn't necessarily protect against variation claims against your estate. So even if you've sliced the orange, your spouse and kids can still claim against your half of the orange. But it does ensure that you at least have that half of an orange that is yours, rather than the orange just automatically passing to your spouse. So in the case that we talked about with Fred and Mary own everything together. They only own that one orange. So if they decided they could slice the orange so that Mary had half and Fred had half, and then at least Mary is sure that she has 50% her half to leave to her son. Okay, excluded assets. This is another tool that we often see. These are types of assets that don't pass through your estate. They don't pass through your will, and so they can't be subject to will's variation. These include things like a tax-free savings account, an RSP, insurance policies, or assets named in joint names with another person. So things where you're directly naming a beneficiary, a separate beneficiary, to inherit that item. You make these designations with the financial institution where you hold that asset. So if you've got a tax-free savings account with Raymond James, it is the Raymond James paperwork that you would have filled out to designate your child, spouse, whoever, as the recipient of that tax-free savings account. When you die, your beneficiary of that account receives it directly. It doesn't go through your estate. So it's not subject to your will. It's not going to be varied. Trusts, our next tool. These are kind of complicated. They're created during the lifetime of a person rather than after their death. And you place the assets that you want to pass through that trust into the trust to get them out of your estate and not passing through your will. Okay, they are not part of the estate, but they are administratively complex and they can be taxed at the highest bracket. So we don't typically recommend these unless you are very wealthy, such as you have over $5 million in assets, or if there is an extreme need to avoid the possibility of a will's variation claim. So there's serious reasons why you don't want particular spouse, particular children to inherit, and we need to do a trust to securely lock it up. Trusts are probably the safest. That's why I have this nice little lock as the slide. They are likely the most secure, safest way to secure your estate, your assets, but they are the most complicated. Next option is mutual wills. This is a way where the couple agree with each other that they're going to make the same will and that neither of them can change the will without the consent of the other. Also a contractual right, like a cohabitation agreement. And again, like a cohabitation agreement, the court will not always enforce the mutual wills, but it's more likely to enforce a mutual will than a non-mutual will. So mutual wills provide some protection without escalating to the level of a trust. So you're not locking things up, excuse me, you're not locking things up as tightly as a trust would, but you avoid some of those administrative complications associated with trusts, like filing their own tax returns every year and being taxed at the highest tax bracket. All right, the final tool, mostly the most simple tool, is a statutory declaration or explanation. So this doesn't protect against someone making a claim against your estate, but it can help weaken the position of that person by showing that your reasons were just and prudent. So if you decide that you want to leave less to your spouse because they are independently wealthy and have no need for your funds, that could be a just and prudent reason which you would document, so that in the event that your spouse wants more from your estate, we can trudge up that declaration and use it in court to show, yep, he had great reasons for not leaving his money to his second wife. All right. So we're going to talk about what each of these types of tools might do for our fictional friends. So Fred and Mary, remember, they're the ones that have been married together for a very long time. Fred has 2 daughters, Mary has 1 son. All their assets are joint. Probably a marriage agreement or a cohabitation agreement would not be desirable at this stage because they've been married so long. They could do one, but most couples are not keen on doing something like that when they've been together such a long time. Severing assets could be a solution. So severing assets, that's cutting the orange. So taking half of their combined assets and giving half to Mary and half to Fred. That could work, provided that they are assured that each of them won't claim against the other. So if Mary trusts that she has her half of the assets, she can leave that to her son without Fred making a claim against it, then that could be a good solution. But she's got to have that assurance from Fred, or sorry, not from Fred. Yes, from Fred, that he's not going to object to her leaving her entire half to her kids. Another way they could do it is exclude assets. They could make changes to their designated beneficiaries on their tax-free savings accounts or their RRSPs to make sure that some of their assets pass to their kids right away. So Mary could change her TFSA, for example, from Fred to her son Brian to ensure that Brian is going to at least receive that money. A trust could be appropriate depending on what their net worth is. And locking it up so that neither of them can change the beneficiaries after the death of the other. And we would recommend they use a neutral trustee in that circumstance so that neither of them would be the trustee in charge of this trust. It would likely be an accountant or a lawyer, or typically the neutral trustees that would be involved. And then mutual wills would help protect against one of them changing the will. So Mary and Fred could enter into a mutual will to be assured that one of them is not going to screw the other one over. But that doesn't 100% protect against the kids making claims against each other when the last one has passed away. All right, Laura, she's our friend who is in a relationship with her boyfriend, Paul, for 5 years. She could do a cohabitation agreement at this stage. It's much more likely to work at an earlier stage of a relationship, such as 5 years in, rather than Fred and Mary, who are 27 years in. Laura doesn't need to really worry about severing her assets or cutting any oranges because she doesn't own anything with Paul, so that won't really help her much. Again, just like Fred and Mary, she could change her designations on tax-free savings accounts or RRSPs to ensure that her kids are going to receive assets that way. That's a really good way to do it. Again, trust could be a good idea if Laura has the money for it. Mutual wills is not helpful since Paul isn't going to be involved in her planning at all. Okay, how would our dear friends Yasmin and Tim use some of these tools? First of all, they could decide to treat David, that is Tim's eldest son from a prior relationship. They could treat him equally to avoid variation claims. That is a really good way to do it. Unless he's done something awful, there's no reason why we can't treat him the same. They could do a cohabitation agreement. Again, it's a little late for that, but if they were willing to, they could do one to provide that they're going to leave each of their children separate assets. We'd have to sever or cut the orange of those assets that they do hold jointly so that that cohabitation agreement can work. I noted that their severing assets would need to do it. Again, they can use the excluded assets. So if they really don't want to leave David, the first son, much of anything, They could decide to change their TFSAs, RRSPs, insurance policies to name the 3 children they raised together and not name David in them at all. That would be a fairly sure way to siphon assets away from David and into the hands of the 3 kids they raised together. Likely a trust wouldn't make sense given that from the facts that I've provided, Yasmin and Tim do not have over $5 million. But we could do a trust if there was very, very bad blood between these step siblings. So if it was so egregious that it would warrant the extra administrative and tax costs of doing a trust. Mutual wills, so agreeing with each other not to ever change the will. It could help, but it, again, same as before, it doesn't always protect against the children claiming against each other. Okay, this is not a legal tool, but it is a tool that I highly recommend. It is family transparency. People are much less likely to claim against an estate or get up in arms or be difficult when they know what's happening, when they know what is going on. Not everyone has the ability to have this kind of transparency with their family for a variety of reasons. So if you can't, you can't. We understand that. But if you are able to have these conversations, which might be a bit difficult, it really pays off. If everyone knows what to expect and have a chance to be heard and feel like it is fair or at least understandable, it is much less likely that there are going to be issues when your estate comes into being. That being said, family transparency is not a legal protection. It is not actually protecting you or your estate or your assets from claims. It is just a way that you have fostered trust in your family to do the right thing and to honor your wishes. So it doesn't provide legal protection, but it does provide emotional protection and trust in the non-legal sense of that term. Regular old faith in other people. So I'm going to give you some examples of how these tools that I've talked about, as well as family transparency, might be used to help our friends here. So Fred and Mary, the 2 that have been married for a long time in a second marriage, they decide that everyone is going to understand the decision. All the kids will understand the decision to give 50% to Mary's son and 50% to Fred's daughters. They discuss this with the children separately, and they receive confirmation that all the kids think this is a fine and fair decision and that it's great. So Fred and Mary just now want to have some assurance as between each other that they're both on board and committed to this 50-50 plan, and that no one is going to change it after the other one dies. So they make mutual wills where they agree that the survivor of the 2 of them can't change the will without opening a right, a contractual right against the estate of the other one. And then they provide copies of the mutual wills to all the children, so everyone knows that it's been done and dusted. And then they go to sleep at night happy in their decision. Okay, so that's one way that Fred and Mary could have arranged their affairs to solve the problem for them. And I'm not recommending that that's necessarily what they do. Or any of these examples that I'm giving you at the end, these are not solutions that I would say, yep, and that's it. That's the solution. I'm just trying to provide some examples of how people normally solve things. Because really, if everyone wanted to solve things in the most secure manner, everyone would be making locked up trusts, which is not realistic. So I'm trying to provide you realistic options here, though they may not be the most legally secure. Okay, so Laura, what might she do? Well, let's say she's going to have a transparent conversation with Paul, her boyfriend, and Paul agrees that for sure Laura should be leaving the majority of her assets to her children. Paul says, okay, well, maybe you can give me a little bit more time to stay in the house if you pass away, perhaps 5 years rather than 3 is what I'd be wanting to do that. And maybe you can leave me $20,000 to get myself started. And Laura agrees that makes sense. So she makes a will and she leaves him 5 years in the house and then $20,000. She signs a declaration, an explanation of her decision, saying that she spoke with Paul about this. This is what he wanted, and he agreed. Laura then goes and names her kids as beneficiaries to her tax-free savings accounts and RSP, so her excluded assets, so that she knows that they're going to inherit those assets after her death. And that is potentially how Laura decides to solve this problem. Now, like I said, these are not always the best solutions, but they are some solutions. I would say that Laura should have probably insisted on a cohabitation agreement with Paul, said, sorry, like in order for me to continue this relationship, we're going to need that. But I am trying to give realistic examples, and clients don't always behave in the most perfect ways. All right, finally, our dear friends, Tim and Yasmin, with their very complicated brood of children. Let's say they decide the best thing to do is to sever their assets, so cut the orange. So each of them has their own estate. So each of them is going to leave enough money to give the other one 25% of his or her own estate, and the other one to their own children right away. So Tim decides he's going to include his eldest son from his first relationship, David. He's going to include him as an equal beneficiary. So what will happen? Let's pretend Tim dies. Yasmin will receive 25% of the estate, and the rest will be divided equally between the other kids, David, Amy, and George. So when this works out, George, the child that Yasmin and Tim have together, he's their biological child together, he's going to inherit a little bit more. He's going to inherit from both Tim's estate and Yasmin's estate. But let's say in this example, they think that's fine because he is their child together, and the other kids do have other legal parents that they can inherit from. So they think that that's fair. Okay, so those are some ways. I hope I have provided you some good information. I know it's probably a lot, and I provided some good examples for you. I think we have a bit of time for questions. If you would like to ask questions, there should be a way for you to ask them in the chat or live, whatever you prefer. And thank you for coming to my presentation today.